Welcome to the July 2023 edition of our HR Focus, your source for news on HR trends and federal, state, and local legislative updates. The content in this news update should not be considered legal advice. Before acting on these legislative updates, employers may need to seek the advice of an employment and labor attorney for additional guidance. Our topic of the month is the Pregnant Workers Fairness Act. The PWFA took effect on June 27th and expands protections to ensure that workers experiencing pregnancy, childbirth, or related medical conditions have the right to reasonable accommodations in the workplace. The law applies to employers with 15 or more employees, and like the ADA, employers must engage in an interactive process with the employee to determine a reasonable accommodation, providing it does not impose an undue hardship. This law builds upon existing protections against pregnancy discrimination under Title VII of the Civil Rights Act. The EEOC has begun accepting charges of discrimination under this new statute for incidents that occurred on or after June 27th of 2023. In addition to accepting charges, the agency has released new additional educational resources, including tips for workers to request accommodations, a Know Your Rights video series, and a revised Know Your Rights poster, which is required to be posted in most workplaces. Regarding the poster requirement, employers must be sure to remove any outdated version of the poster and replace it with the updated version, which is available for download from the EEOC's website. As a reminder for New York employers, you also have an obligation to not only post all required federal and state notices in the workplace, but those notices must also be provided electronically, either by website or by email. And because this federal posting specifically applies to both applicants and employees, you should ensure that an electronic version of this notice is provided to all applicants. The EEOC will issue regulations on the law by year's end. Other federal legislative updates include the release of the Biden administration's spring regulatory agenda. On June 13th, the Biden administration released its spring 2023 unified agenda of regulatory and deregulatory actions. The agenda is important as it can provide insights about potential legislation in 2023 and announces initiatives of the various federal agencies, including a listing of all the regulations the departments within the DOL expect to have under active consideration for promulgation, proposal, or review during the coming 6 to 12-month period. The USDOL, OSHA, and OFCCP have some initiatives of note on their regulatory agendas, which may impact federal employment laws and regulations this year and beyond. Some notable items on the agenda include the DOL's proposal to amend overtime requirements under the FLSA. This proposed rulemaking will have an impact on the salary level requirements for exempt employees. Originally scheduled to be issued in April of 2022, the DOL's proposal to the overtime regulations has now been pushed back to August of 2023. Additionally, OSHA has a proposal to resuscitate its 2016 illness and injury reporting regulation. If finalized, OSHA regulations would be amended to require establishments with 100 or more employees in certain designated industries to electronically submit information from their OSHA Forms 300, 301, and 300A to the agency once each year. OSHA would also update the classification systems used to determine a list of industries covered by the electronic submission requirement. Finally, it would also roll back the current requirement for establishments with 250 or more employees not in a designated industry to electronically submit information from their Form 300A to OSHA annually. OSHA also still has a final COVID-19 standard for healthcare settings on its agenda. Both measures were expected to be final in June, but at the time of this post have yet to be released. Meanwhile, the OFCCP has had the modernizing of affirmative action and non-discrimination obligations for federal contractors and subcontractors on its agenda, and final rulemaking is now scheduled to be released in December of 2023. In other news, the National Labor Relations Board has returned to its prior standard for determining whether an individual is an independent contractor under the National Labor Relations Act, which includes a 10-factor test. In the Atlanta Opera Inc., the board returned to the 2014 FedEx Home Delivery Standard for determining independent contractor status under the Act, thereby overruling the Super Shuttle decision from 2019, which based independent contractor status on entrepreneurial opportunity for gain or loss. In its decision, the board explained that entrepreneurial opportunity would be considered along with the traditional common law factors. As a result, in evaluating independent contractor or employee status, the board will apply the following 10 factors. Who controls the details of the work? Is the work performed a distinct occupation or business? Is the work being performed typically done under the supervision of an employer? Does the work require special skill? Who supplies the tools or equipment? The length of the engagement? Is compensation based on time spent or completion of the job? Is the employer in the business of the work that is performed? Do the parties believe they have created an independent contractor relationship? And whether the employer is in business. Due to this decision, the threshold for finding employee status will be much easier for the board to establish. The Supreme Court has strengthened protections for religious accommodations in the workplace with its recent ruling. On June 29th, the Supreme Court issued a decision in Groff versus DeJoy, Postmaster General, which strengthens protections for religious accommodations in the workplace. At issue in Groff's case is Title VII of the Civil Rights Act, which prohibits religious discrimination in the workplace and requires employers to reasonably accommodate an employee's religious observance unless that accommodation imposes an undue hardship on the business. In 1977, the court defined such a hardship as an accommodation that would place more than a minimal burden or de minimis cost on the company's operation. Instead, with this recent ruling, the court ruled that an undue hardship is shown when a burden is substantial in the overall context of an employer's business, and the test must be applied in a manner that takes into account all relevant factors, including the particular accommodations at issue and their practical impact in light of the nature, size, and operating cost of an employer. The court said that the ruling should result in few, if any, changes to the EEOC's guidance explaining why no undue hardship for religious accommodations is imposed by temporary cost, voluntary shift swapping, occasional shift swapping, or administrative costs. However, due to these potentially increased obligations to meet an undue hardship threshold, it is recommended that employers train managers and supervisors on handling religious accommodations requests and the interactive process, and that you review and update your policies as needed. In some cases, it may become imperative to seek the guidance of an employment and labor attorney to determine if an undue hardship exists. Notably, the court's opinion did not address whether the Postal Service should have accommodated Groff's request not to work on Sundays, and the ruling sent that back to the lower court to apply the new undue hardship standard. Lastly, in an update on its EEO1 Component 1 data collection landing page, the EEOC has announced a pushback of the tentative opening of the 2022 EEO1 portal to the fall of 2023. The EEOC originally anticipated the portal to open in mid-July, but due to the agency completing a mandatory 3-year renewal of the EEO1 Component 1 data collection by the Office of Management and Budget, the opening has been further delayed. A final opening date, as well as the opening of the Filing Support Message Center, will be posted on the landing page once available. HRWorks will monitor developments on this topic and provide additional information as it becomes available. Next up are state legislative updates. Colorado has enacted legislation restricting employers from requesting age-related information from job applicants. On June 2nd, Colorado Governor Jarrett Polis signed into law the Job Application Fairness Act, prohibiting employers from inquiring about a job applicant's age during the hiring process. The specific information the law forbids employers from inquiring about includes an applicant's age, date of birth, and the dates of attendance at or graduation from an educational institution. If employers request that applicants provide application materials such as transcripts or graduation certificates, employers must notify applicants that they may redact information that identifies their age, date of birth, or dates of school attendance or graduation. These restrictions apply only at the time of an initial employment application. The law does permit employers to request that an applicant verify compliance with age requirements in an initial employment application, but only under limited circumstances where age is a bona fide occupational qualification pertaining to public or occupational safety. Such information is required under federal law or regulation, or such information is required under a state or local law or regulation based on a bona fide occupational qualification. The law becomes effective on July 1st of 2024, so employers have some time to review their hiring practices, including employment applications, to ensure compliance with the law's requirements. Minnesota has passed a statewide earned sick and safe leave law. The law will entitle covered employees to earn up to 48 hours of paid leave per year, and it will apply to all individuals or businesses with one or more employees. There is no small employer exception. The law covers all employees, including part-time and temporary employees, performing work for their employer in Minnesota for at least 80 hours in a year. Employees may use leave once they have performed at least 80 hours of work in Minnesota in a year. Employees may take leave for a range of reasons, including time off to care for a covered family member. Employees may carry over any unused leave from year to year, but the employer may cap the number of hours accrued at 80 hours. Employers need not pay out unused leave at termination of employment for any reason. However, if an employee separates but is rehired within 120 days of the separation, the employer must reinstate any previously accrued but unused leave that was not paid out upon separation. Employers must give notice to all employees regarding their leave rights, including the amount of leave, the accrual year, the terms of use, requirements for providing notice of use, and prohibitions on retaliation. If an employer provides an employee handbook to its employees, it must also include notice of employee rights and remedies in the employee handbook. The Minnesota Department of Labor will prepare a model employee notice. The new law takes effect on January 1st of 2024, and it will not preempt any local paid sick leave ordinances. Minnesota has also joined the growing number of jurisdictions that have enacted a paid family or medical leave program for its employees. Starting on January 1st of 2026, Minnesota employees will be able to take up to 20 weeks of paid family and medical leave per year. The paid family and medical leave insurance program will be funded by both the employer and employee through payroll deductions. Certain portions of the statute will be implemented before January 1 of 2026 so that the state can build the necessary infrastructure to administer it by the official start date. The statute applies to all employers regardless of their size and the number of employees located in Minnesota. Almost all employees, with limited exception, will be eligible for PFML benefits if they meet the financial eligibility requirement under the law, which is having earned at least 5.3% of the state average annual wage over their base period, defined as the most recent 4 completed calendar quarters before the employee's application for benefits. Coverage will fall into 2 categories: leave for the employee's own serious health condition, and other leave, including family care, bonding, safety, or a qualifying exigency. An employee may take up to 12 weeks of paid leave for their own serious health condition and up to 12 weeks of paid leave for bonding, family care, safety, or a qualifying exigency. However, employees are limited to an aggregate of 20 weeks of paid leave in a benefit year. An employee may also use the leave intermittently for any of the covered reasons under the law, but an employer may limit intermittent use of leave to 480 hours in any 12-month period, in which case the employee would be able to take any remaining leave on a continual basis. Employees will not receive their full wages for PFML. The state will apply a maximum weekly benefit amount that will be computed by the statute. An employer may also offer a private plan so long as the plan provides benefits and protections that are the same or greater than those under the public plan, and that private plan has been approved by the division. Employers have plenty of time to get up to speed on the new requirements, adjust their policies, and plan for changes to come. In the interim, the state is expected to issue regulations and frequently asked questions to provide insight into various areas of the statute that are not currently clear. HR Works will continue to monitor this law and provide updates on any significant developments. On June 21st, 2023, the New York Department of Labor's amendments to the New York WARN regulations took effect with some sweeping changes. Under the amended regulations, the definition of a covered employer were expanded to count not just employees at a single site of employment in the state, but also employees who work remotely but are based at the employment site. Notice to affected employees must now also include relevant information known at the time of the notice, such as information on severance packages or financial incentives if the employee remains and works until the effective date of the layoff, available dislocated worker assistance, and if the planned action is expected to be temporary, the estimated duration. The amended regulations also add additional notice requirements to the New York Labor Commissioner. Oregon has issued an amendment to align the Oregon Family Leave Act with Paid Leave Oregon. Senate Bill 999 was signed into law on June 7th. The law attempts to address conflicts between the Oregon Family Leave Act and Paid Leave Oregon. Most notably, the legislation amends the OFLA to clarify that if the reason for an OFLA leave also qualifies under Paid Leave Oregon and/or the Federal Family and Medical Leave Act, the leave must be taken concurrently and not in addition to Paid Leave Oregon and/or FMLA. In other words, the concerns about stacking leave, specifically taking an OFLA leave prior to turning in a claim for benefits under Paid Leave Oregon, have been eased. The legislation also permits employers to adjust the benefit year under OFLA beginning in 2024 to be aligned with the Paid Leave Oregon law, which will allow for easier implementation of concurrence of leave. Other changes include adding a definition of family members under OFLA to be consistent with those under Paid Leave Oregon. Impacted employers should consider revising any OFLA policies to align with the new definition of family members and clarify that OFLA leave that also qualifies under Paid Leave Oregon and/or the FMLA must run concurrently. Employers wishing to change the leave calculation period under OFLA may be to be based on a rolling forward benefit year to match Paid Leave Oregon must give 60 days advance notice to employees. And lastly, Texas's law regarding hairstyle discrimination will take effect soon. On May 27th, Governor Greg Abbott signed into law the Creating a Respectful and Open World for Natural Hair Act, aimed at protecting citizens from hair discrimination. Effective September 1st of 2023. The Crown Act amends the Texas Labor Code to prohibit discrimination on the basis of hair texture or protective hairstyle, such as braids, locks, and twists, which are commonly associated with race. The law will apply to employers with 15 or more employees. Considering this legislation, employers may wish to review their equal employment opportunity and dress and grooming policies to ensure that those policies do not run afoul of the Crown Act. Need more information on the content in this edition? HR Works is here to help. Current HR Works clients may contact the virtual helpline or their HR consultant for additional information on any of these legislative updates and next steps. Non-HR Works clients may contact us for HR solutions by calling toll-free at 1-877-219-9062 or visiting our website. Before we close out this edition, we wanted to let you know that HR Works will also be hosting a free webinar on Wednesday, July 26, entitled Show Me the Money, Preparing for New York's Wage Disclosure Law. In this 1-hour program, we will review the requirements of New York's wage disclosure law, including additional considerations for implementing the law, as well as best practices for compliance and the benefits of being transparent about pay. SHRM and/or HRCI credits will be available for attendees of the live session. We hope that you can join us. And with that, we would like to thank you for watching this edition of the HR Focus.